Domestic violence allegations are unfortunately a part of many divorce cases. If you find yourself in this situation, there is a recent decision by the Arizona Court of Appeals that you should be aware of. It clarifies how domestic violence may impact which parent can make decisions relating to children. Mervyn Brody, he is a partner and family law attorney at Jaburg Wilk, and he is here to explain all of the parameters. And I do want to clarify, this is not about parenting time. This is specifically about legal decision-making for the child, correct?
That is correct.
All right, and so what is the impact of domestic violence?
Let's start off by saying domestic violence is always bad. However, our law defines two categories: significant domestic violence and other domestic violence, and they have a different impact when it comes to deciding legal decision making.
All right, let's start with significant. What is significant domestic violence?
Significant domestic violence is not defined by the statute. However, we look at items like pervasiveness, the seriousness of the incident, and the impact. Once we make that determination, the evidence will indicate whether this is significant or not. If it is significant domestic violence, our law precludes an award of either sole or joint legal decision-making to the offending parent.
All right, so we hear that term significant domestic violence, and there's a reason you're not stating what that looks like because it's different, correct?
Right. It is not defined by statute.
Okay. So what is the result if the court determines that the domestic violence, in fact, was significant?
That is the end of the inquiry. The parent who committed the significant domestic violence is precluded from having legal decision-making authority, either sole or joint, in respect of the child.
So it ends right there?
That's the end of the matter.
All right, so what if the court says, no, this is not significant?
Even if the domestic violence is not significant, we know that domestic violence is not in the best interest of the children. The law, therefore, imposes a presumption that it is not a good idea for the offending parent to have joint or legal decision-making, but that presumption can be overcome with appropriate evidence.
What about if someone says, you know what, okay, so I have been accused of significant domestic violence, but I'm in rehab, I'm going to some sort of counseling to try and get through this?
If the domestic violence is significant, remember, that's the end of the matter. If it is not significant, and you give evidence perhaps of having attended rehab if there was alcohol or drugs involved, having attended possibly a batterer's program, those factors can assist the parent in overcoming the presumption in respect of not significant domestic violence.
Is there a statute of limitation in the sense that where you have it, once it's deemed significant or not significant, can you go back and change it later?
Once the court has made its decision with regard to legal decision making and its finding of significant domestic violence, unless you appeal the decision, that decision will be binding on your case and you will be subject to the restrictions flowing from that.
So the bottom line, we need a legal expert to help us.
We need a legal expert, but the overriding advice is domestic violence is bad, don't do it. It is even worse if you want to be involved in your children's lives. Do not commit acts of domestic violence. It is a bad idea in every respect.
Thank you so much. Great information, Mervyn. Thank you. If you need legal help, Jaburg Wilk is available to you. They're located at 3200 North Central Avenue, Suite 2000 in Phoenix. 602-248-1000 is the number to call, or visit the website jaburgwilk.com.